Oh, hey there, folks. Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com. Elder Law Care Warriors. Great question came in today from one of our subscribers on our YouTube channel, elderlawcare.com. Hey, Patrick, does being a caretaker influence estate planning? Or how can being a caretaker, or how should being a caretaker or caregiver for a loved one influence your estate plan? Folks, really important question, and oftentimes the nuances of this relationship, caregiver for an incapacitated loved one, is overlooked, okay? A lot of legal technical nuances to this, and really important in order to properly protect and preserve and pass your assets down to the people you love the most. So folks, get your pen out, sharpen that pencil, pull up your chair and get your notebook out, because we're gonna learn how to slay that fourth-headed beast right there, the metaphorical nursing home right there. A couple of rules of engagement, things to think about here, folks. During the process when your loved one first starts becoming incapacitated and disabled, whether you're a spouse, more so for children, and we're working with some families in this scenario right now. Really, really important, and you want to write this down. Please write this down, because it's an important legal technical takeaway. You want to make sure your elder law attorney creates what we call caregiver agreement or caregiver contract. That way, when your loved one is still at home and you're the caregiver, caretaker for them, you're able to pay them from your assets in your resource pool, your finances, and it will not be construed as a gift that will create a penalty period that will disqualify you for a period of time from Medicaid benefits. Because Medicaid says you can't give money away. However, if you're paying family members to render caregiving medical services for you, it may be completely legitimate and honest. However, now if you come to a point where you can no longer be cared for at home any longer due to a fall like my late dad, and you're applying for Medicaid benefits, Medicaid is going to scrutinize all your financial records. And if they see checks that you're paying out to family members, they're going to automatically, typically assume they're gifts that you're making to them. And then you're going to have to articulate and memorialize and advocate to say, hey, they weren't just gratuitous gifts. I was paying them for caregiving services. They left their job, they were taking time out of their family's lives, and they're rendering medical services for my medical care that allowed me to stay out of the nursing home. So that right there, you don't want to get into that fight or arm wrestling match with Medicaid. So the solution there, folks, is to make sure you have a proper caregiving agreement drafted by an experienced elder law attorney, which is completely permissible pursuant to the Medicaid rules and regulations. But you need to have that Medicaid caregiver agreement drafted, prepared, and signed in advance of ever making payments or disbursements to family members. So that's numero one for caregivers as far as estate planning considerations. The other biggie right here, folks, is not in the context of a caregiver. If your loved one is already in a nursing home, your spouse, say husband Bill, already in a nursing home, and wife Mary, like my late mom, was taking care of my late dad. Really, really important for the community spouse to have what they call a Medicaid will. It's a testamentary will under the federal Medicaid rules that say the following. If the wife Mary, the community spouse, the presumably more healthy spouse, ends up checking out first, predeceasing the nursing home spouse and going up to the cloud first, it would be catastrophic if they do not have anything in place, either no will or a trust. Typically, and it's going to say everything goes to who? Their beloved spouse. But unfortunately, their spouse is in a nursing home. So two bad things are going to happen. Number one, their spouse in a nursing home is going to become the immediate beneficiary of all the deceased community spouse's assets, and it's going to immediately put them over asset, typically over the $2,000 Medicaid threshold. What is that going to do? It's going to immediately put on pause their Medicaid benefits until they spend down all those assets. And folks, in reality, there's not a lot of Medicaid crisis planning strategies out there these days. They took away the community pooled trust to shelter that asset as of March 1st, 2024 here in the Commonwealth. So there's not a lot of other crisis planning strategies, unfortunately, available. So that could be catastrophic. Now all those assets would be in the hands of Medicaid and potentially the nursing home for any overage bills, and that money would have to be spent down and get under that $2,000 threshold before Bill can get back on Medicaid for Medicaid to start resuming payment of Medicaid or nursing home medical services. So folks, hopefully this video was helpful for you. Please scroll down, post a comment, post a question, because a member of our team will get back to you as soon as possible. Also, folks, please be sure to click the subscribe button and click that notification bell, because we will continue to keep you updated with other important elder law videos. Folks, if you'd like to learn more, strongly recommend pick up a copy of my book on Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Thanks for joining us here today, folks, at elderlawcare.com.